Hi, everyone. This is Jason Feller with Feller Realty, and this is a continuation of my video series on the Texas residential real estate forms. Today, I wanted to go over the documents that you would actually utilize for submitting a contract in the state of Texas. The first page here that you're seeing is the information about brokerage services form. This form is required by the Texas Real Estate Commission to be handed out by an agent or a broker when they have any kind of substantive discussions about real estate with a prospective buyer, seller, or a tenant. It just causes more of a connection or relationship with the explanation of what the fiduciary duties are of the broker agent in regards to each one of those types of clients, whether that's the, like I said, the seller, the buyer, or a tenant. And this form, although you are initialing off on the bottom where it's highlighted, you are not agreeing necessarily to all of the terms. You're just acknowledging that you've seen it. And in actuality, in Texas, you do not have to even sign this if you don't want to. So the next form that you'll see that I utilize and most agents should utilize in the state of Texas is a buyer's rep agreement. This set of documents just shows the commitment on both sides, the buyer's commitment to the agent, and of course the agent's commitment to do everything that they can for their client. This document outlines the parties to the contract. So I've utilized a Joe Buyer with some false information there. And then, of course, my information as the broker. So those would be the two parties to the contract. Then you've got your definition area, which basically you're defining the market area or the city in which that representation will be occurring. So for me living in Dallas, it would be the Dallas-Fort Worth Metroplex. So that's going to include the neighborhoods north, south, east, and west. To give a little flexibility on that area. The term is, how long do you want this agreement to be in place? I've seen agreements as short as a day. I've seen agreements isolated to one property showing, and then I've seen agreements that are a year long. So it just really depends on what each one of you feel comfortable agreeing to. Typically, I like to do 90 days and then extend from there if needed. And of course, that just shows the terms, when it starts and when it ends. Then you've got 5 and 6, just explain the obligations of both parties. That's the broker agent as well as the clients. And it's just basically explaining that the client will work exclusively with this broker, and that the broker will assist in their best efforts to, acquire a property in that market and negotiate to the best of their abilities for that client. Then at the bottom, you would initial either one box or two boxes if there's more than one buyer. Second page is there's an important section here, intermediary. This section is discussed a lot. It was referenced in the information about brokerage services form, which I initially showed you, that is required by the state of Texas to be handed out to each potential client. The intermediary status, this comes about in Section 8. It's saying whether the client would or would not allow this to occur. Essentially, intermediary is, in this situation, would be the buyer would be represented by me. They would go to a property that just happened to be listed by me as well. And at that point, I would be in a situation where I potentially could be trying to represent the buyer and the seller at the same time. There's a lot of specifics that are required, as you can see in the under 8B under notice. There's a lot of details that are required for this to happen, and both parties are not always accepting of this. And if that's the case, you can have another agent step in on your behalf on one side or the other to make it a little bit more appealing, or not do it at all. So that just discusses that in depth. Then Section 9 is talking about competing clients. That's basically just saying that the buyer is acknowledging that myself or the broker agent that is representing them might show the same property to another client that they have, even if they have shown that property to them. Just because they have an exclusive relationship doesn't mean that the properties that they show are exclusive only to that person. So then you've got Section 10 is confidential information. And this is just explaining that any information exchanged between the buyer and the broker agent is not able to be, told or explained or expressed to anybody else. And basically, that's information that is acquired during the term of the agreement, which is on page 1, which in this reference is 410 to 710, so 3 months. So anything that was said or occurred in that time frame cannot legally be expressed to another party. Broker's fees, number 11. This goes over how the broker is compensated. And the reason this is discussed here is the typical commission, not guaranteed, but the normal typical commission is 3% for a buyer's agent to earn on the completion of a sale for their buyer. So in here under 11A, you would identify the minimum commission that you are willing to accept under this agreement on a purchase, as well as a rental. So in this instance, I have referenced 3% as the minimum commission and 50% of 1 month's rent as the minimum fee for a rental. The reason these are, put in these blanks is if a house that we went to see or wanted to see was only offering 2%, then essentially what this agreement is stating is that the buyer would be responsible to make up that difference. So they would actually owe 1% commission to the agent. Again, that's not that common, but it does happen. It also comes into play with for sale by owners. Sometimes they have a reduced fee that they're willing to pay since they're not in the actual MLS. And then the only other time I typically see this is on new construction sometimes. If the buyer has gone in, looked around at the properties and the model, and never filled out a representation card with that builder, then a lot of times the builder will deny paying them a commission if they do come back and actually write an agreement. So if a buyer is going in and they're going to be talking to a builder, even if they're not 100% sure what they're going to do, they should still let them know, fill out the card, and let them know that they're represented in this process. And you go down to the next important section is 11G. That's the protection period. And basically what that says is that if the buyer and the broker agent were engaging with a property, went and were looking at a property and nothing happened, it never went under contract, it never, entered into a sales situation. But within 90 days of the end of the period that was negotiated on page 1, so that 3-month period, 6-month period, 1 day, so within 90 days of that time frame, if a buyer was to enter into a contract on one of the properties that broker agent had shown them, then at that point they actually are due a commission, and that is what is being outlined in 11G. 11H is escrow authorization. Basically, that's just saying that the client buyer is agreeing to have the title company pay the fees that are within this agreement, and they would pay those fees directly to the brokerage upon the closing of the property. 12, 13, and 14 of this page are basically legal terms. These sections are in place to discuss if there was a dispute that came about for some reason in the transaction between the buyer and the agent, and how that would be handled, initially mediation, how default is handled, how the attorney's fees are handled as far as buyer paying for theirs, seller paying for theirs. 16 is the addenda. Basically, that's just showing what forms would be attached to this agreement. On here, I've checked information about broker services. That is the form that we looked at initially that talks about the fiduciary duties of the broker agent to the client, whether that's a buyer, a seller, or a tenant. 17 is special provisions. I typically do not put anything in special provisions of any of the contract documents that the Texas Real Estate Commission puts out. The reason that is a lot of times it is considered practicing law. I utilize this section only if there is a key phrase or element of the contract or agreement that the buyer or seller wants to be in place. And this comes from an attorney in which they have acquired, not from an attorney that I have acquired. So if there's a specific term or phrase that they want in there, then I can put that in there per the attorney. 18 is under additional notices. That's just explaining that, of course, broker fees or sharing of fees are not fixed or controlled or recommended, suggested in any way between brokers or other realtors discussing these, these commission rates or these fees. There is norms and there are things that happen a lot of times, but that is not a fixed number. Also discussing in B is going over the fact that an agent or a broker agent has to provide the same work, skills, services to everyone. All protected classes. There's no discrimination that would be allowed. Everything has to be equal. And then finally, we come back to the signature page, and that is where the agent and the buyer or buyers would sign off on this form. Now, proceeding to the actual residential contract. This is page 1 of the contract. What it does is it explains the parties of the contract. So the buyer and seller's names at top, the subject property in which the offer is being put on. And then it goes in, talks about the improvements, accessories, and exclusions. And what that is things that are attached to the property that the seller is claiming that they are going to remove from the actual property and take with them. And those are identified in 2D. I've put in here surround sound speakers, as well as the wall mount and flat screen TV in the family room. They will have identified these in the MLS, and I will have just transferred those into that section. And then section 3 is the offer price, how much you're putting down, and then the remainder in that is going to be utilized as a loan or a seller financing. It's just the the difference between the offer price and the amount of money that's being put down. So for this instance, it's an offer of $500,000, putting $100,000 down, leaving a $400,000 amount of money that needs to be handled. So in here, I've identified third-party financing addendum, and that's at the back of the contract, and that just explains which form or which kind of financing that the buyer will be utilizing to purchase this property. So whether that's FHA, conventional, seller financing, VA, and then it identifies, any time periods, APR rates, etc. I'll go deeper into that when we go over that form. Section 4 is utilized basically to explain any special relationship that needs to be disclosed. So if an agent is buying the property for themselves, if a transaction is being handled by someone that's representing someone else, and it's just a section there for special relationships. Section 5 is the earnest money. That is the money that is put down with the contract as consideration to show good faith for the contract. That is deposited with the title company. In this reference, I've got $5,000. In our area, it's typically 1% of the sales price. You would deposit that with your local title company that you utilize. In here, I put Mr. Title as a generic name, and then you put the address, and there's another section in there, buyer shall deliver additional earnest money of within a certain amount of days. That section is utilized. Some people will split the earnest money up. So say, for instance, they did $2,500 as earnest money to the title company initially. And then within 7 days, they decided if they're still in the contract, they'll put another $2,500 down. So if they were going to split it up and put different amounts or, add additional earnest money to the contract, that's where you would indicate that. Section 6, again, deals with the title company. And what that is the title policy and survey. So you're saying the title policy, which is showing that the property has clean title to be transferred over to a new buyer. They're going to go through, make sure there's no liens or encumbrances on title that would cause a conveyance problem. And in this area, you can negotiate whether the seller or the buyer is going to pay for this policy, but 99.9% of the time, it's the seller that will pay it unless it's a very aggressive multi-offer scenario and someone's just trying to sweeten the pot on their contract offer, and then they might offer as the buyer to pay for that. On a $500,000 house, you're probably looking at $3,000 or $4,000. So it's not just a few $100s that we're dealing with here. Then at the bottom of that page, of course, you would initial one or both spaces if there's one or two buyers. Number 8, where I have that checked, is showing that it's 8.2. It says will be amended to read. That's in case there's any shortages in the area on title. If there's any issues on title that need to be, corrected and dealt with, then this is a section where you can negotiate as well on whether the buyer or the seller would handle this. And I'd say half the time, 8.1 is what is actually checked. It says will not be amended or deleted. Title commitment. So section B is saying that within 20 days of receipt of the executed contract, the title company will turn a title commitment back out for the parties to see. The survey, which is section C, is the outline of the property utilized usually on a legal sized form. It's usually has a blue line around the entire diagram of the property, how the house sets on the property, the fence lines, the property lines, if there's any pools or streets or different things that would be identified in that area. So that's what C is. And then most of the time you'll see C1 is utilized on these offers. And I have in here that within 7 days after the title company receives the executed contract, that a survey will be ordered or an existing survey will be accepted by the title company. So in Texas, you're allowed to use a past survey if nothing has changed on there. You haven't changed the fence lines, you haven't added a room to the back of the structure that changes the property lines, or added a pool to the backyard. So anything that would actually change the structure of how the property sets on the lot, or what basically is on the lot. Then at that point, if you haven't done anything like that, you can submit a T47 affidavit. And essentially what that's saying is that you're certifying that nothing has changed on that property and that the title company can go ahead and accept the survey that you're providing. If they don't accept the survey that you're providing, then the bottom section of C1 is saying who would have to obtain a new survey. So would that be at the seller's expense or the buyer's expense? The other two options under C are just straight out saying that within a certain amount of days that the buyer, or within a certain amount of days the seller, will purchase a new survey. Then you've got section D, which is discussing objections. This section is utilized if somebody has a specific requirement that they're going to want the property to be able to utilize. And I say they wanted a pool in the backyard, and the whole reason they were moving is to be able to build a pool in the backyard. And the survey comes up and shows a utility easement across the middle of the backyard. If that happens, then that could possibly restrict them from being able to put a pool in. And if they deem that situation could happen, then they have the rights within the days that we have indicated in the second blank. 2 days is what I've put in here. So within 2 days after they received that survey, if they realized that they weren't going to be able to put a pool in the backyard, then they could cancel the contract legally, or they could waive the requirements or objections. Then you go into the next page, which what I like to say is this page it's just very specific sections that discuss various situations that the subject might be part of, and then how each one of those are handled. So whether that's tax districts, tidewaters, annexations, and I always suggest that that's one that the buyer should read thoroughly through. If they have any questions, they should ask an attorney for sure. Then, of course, as with all the pages, you initial 1 or 2 spots on the bottom of the offer. Then we come into 7, which is property condition. This is where the contract states that all utilities have to be on for the property so that a valid inspection can take place that would identify any deficiencies that the property might have, and then it would allow those to be dealt with. 7B is talking about the seller's disclosure, whether that has or has not been received by the buyer. The seller's disclosure is a report that is the condition of the property to the best of the seller's knowledge. That would identify, elements of, what the property might have, whether that's a pool, an oven, AC, garage door openers, etc. And then if there's any deficiencies or problems with any of these items. And that's all encompassed within this report. And it's explaining here, like I said, on 7D, 1 would say that you have received the report. And then 2 would be, how long, I'm sorry. 1 says if you've received the report, 2 says you haven't received the report. but you're given a set amount of days in which, from the execution date of the contract, that you have to have received this report, or you could terminate the contract. 3 is saying that you're not required to receive this, which I personally have never utilized B3. Then you've got Section C, which is talking about disclosing whether the house was built prior to 1978, which is in that is in here for that reason of lead-based paint. Before 1978, lots of homes had lead-based paint, and they've been found to be problematic for children that might, bite on a windowsill or somehow ingest the lead-based paint that would ultimately make them sick. And we've got 7D. This is the acceptance of property condition. Essentially, what we would utilize this is, I'd say 90% of the time you would do D1. And what that means is you're just accepting the property as you see it that day without any further information of needed repairs or deficiencies. So you're not asking for any specific repair to be done prior to inspections. 7D2 is where you would be asking for something as part of the initial agreement. So let's say you saw a window that was a large window that you knew was going to be $400 or $500, and you wanted that handled no matter what the inspection came back with. So you would select number 2, and then you would go in that space and identify what repair you specifically were negotiating up front. Then we come into 7H. This is the residential service contract. And what this is a 12-month warranty, essentially, on a property. You are paying for a policy that, depending on the amount of money that is given from the seller to the buyer, might pay for more or less items to be covered for that 12 months. Basically, it's an insurance policy, since that buyer has never lived in that property, and they just want to make sure that if something would break during that 12 months, that they're covered for a minimal fee of $50 to $75 service call fee. Number 9 is the closing date. So this is the date in which the buyer is actually wanting to close on the property. So in reference here, I did a month from today, which would be 5/10/2019. And with that, that's just saying when we would like to close. It doesn't mean it has to, but that's the initial projected date that is being negotiated. Possession. This is saying when you actually, as a buyer, want the property. So when do you actually want to move in? 99% of the time, they're going to check the first box that says upon closing and funding. That just is usually the 5/10/2019 that is indicated in the closing date space that we just discussed. Sometimes you will have a temporary residential lease. That can be put in place if a seller comes in and they say they need 2 days to move out after the closing. So you might have a 5/10 closing date, but you might have a 5/12 possession date. And so you work out the agreements on an addendum to contract that states, was there any fee involved in the seller living there for 2 days, rent-free, the utility costs, whether they can have pets. It basically turns the situation into where the buyer becomes a landlord for those negotiated days, whether that's 1 day, 2 days, 3 days, and then what terms are attached with that agreement. Special provisions, which is number 11. Again, I typically do not utilize this personally due to the implication of practicing law. So I usually only save this section for attorney written statements that they are telling me that they wanted. Number 12, settlement and other expenses. So 12B, in this section, you would put in any amount of money that is being asked for from the buyer to be paid by the seller. So if you were doing a government loan and there was certain expenses that the lender said the seller has to cover, and you would put those in here. So, or say the buyer wanted to keep some money for repairs after they close, and they decided they wanted to ask for $3,000 in closing costs to be covered by the seller. Essentially, that's just taking $3,000 off of the initial $500,000 offer that this contract is showing, but it's just coming in a different way, because this would actually be cash that would need to be paid by the buyer at closing, and essentially they're just asking for the seller to cover that so that it leaves them with that said amount after closing. This page, basically the end of 12 through 17 is just discussing more legalese. You've got section 13 is discussing the prorations of taxes. And this is, let's just say the property closed June 1st. Then what would happen is the seller would be required to pay for the taxes from January 1 to June 1st, and they would pay those to the buyer at closing. That would be a credit to the buyer. And then the buyer would ultimately be responsible for the entire tax bill at the end of the year. So they're given the money for them to pay the entire bill, but it comes as a credit at closing. 14, casualty loss. This is a section that is just discussing basically the property has to be in the exact same condition as to what it was on the day of contract. So if something happens after everything has been signed, but you're waiting to close, say a fire, a flood, a hailstorm, a tornado, something that affects the condition of the property. If that happens, the seller is obligated to return the property to the condition in which the buyer contracted the house. So if the roof was totaled, they would be required to replace that roof, and so on and so on. Number 18 is just talking about the title company. It's explaining that the escrow agent is not actually a part of the contract. They are just facilitating the transfer and make sure that the title is clean and that it can be conveyed over to the new buyer. And they just are making that swap and getting the money from the new mortgage company to pay the current seller's mortgage company off. They do that all at the table and close and fund everything, usually within 4 or 5 hours on one day. That properly allows it to transfer over to the new buyer. You've got, on this page, you got 21, which is explaining the contact information for both parties of the contract. So to the buyer, so if any notifications were being sent from the title company, they would utilize this section to identify where to send it. And the same goes here for the seller. 22 is agreement of parties. This is where you would indicate any addenda that is being attached to this contract. So for this one, I'm using a third-party financing addendum. So I've got that checked. And that's just explaining how the buyer is going to finance the property. Sort of like I discussed on page 1, if they have $400,000 left over from the offer price, how are they going to make that whole number complete? What type of financing and the details around it. Then you've got the second box I have checked here is addendum for property subject to a mandatory membership. Essentially, that is an HOA. And that form identifies which HOA it is, who's responsible for the fees, how long the title company has to give any documents relating to that HOA over to the buyer. And so it just goes over all the details of how that's handled at the title company. And then you would check any other of these boxes if there's specific forms are going to be required for your transaction. You would check these boxes off, and then you could go over in detail what they actually were. 23, an important paragraph. This is the termination option, or what is usually called the option period. And what that is you are paying a normally nominal fee. I like to see, somewhere in the 0.5% to 1% of the house on this. I'm sorry, it'd be actually even less than that. Excuse me. I've got it down that the seller's paying $250 for 7 days. And what that is this is the negotiated time in which the buyer has the unrestricted right to cancel the contract for any reason. They just decide the color of the house is ugly. They just don't like it. Whatever the situation is, they get cold feet, they can cancel, they can get their earnest money back from title, and they have that right within those 7 days. But if they do cancel, the $250, which is normally in a check form, upon execution of contract will be written to the seller's name and will be given to that seller from the buyer. They can cash it, keep it, whatever they decide to do with that money, it's their choice. Typically, I tell them to deposit it in their bank account. The next page is the first addenda. And what that is the third-party financing addendum. We discussed it a couple of times during the offer documents. And this is showing what type of financing. So for this one, I've chosen conventional financing. That's your normal run-of-the-mill loan with a $400,000 amount in the first box, which is the remainder that would be needed outside of the $100,000 being put down. Typical 30-year mortgage, that could be a 15-year mortgage, that could be whatever numbers you have. And then I've got interest not to exceed 5%. That's up today's rates. That could be 3 or 10 or whatever the going rate is, and then whatever the maximum that you're putting in there. So you want to put all this information in here for a couple of reasons. The not to exceed is, let's say that you planned on using this financing, and then it came back and the mortgage company said, well, we can do the loan, but it's going to be 8%. And that just was way more interest on the loan than you ever anticipated. If you have a maximum of 5% here, and it's agreed to in this contract, by both parties, buyer and the seller, then you could opt out of that contract because you were not able to get this rate that you initially put in here as a stipulation. Then you've got the other types of financing down below that one, depending on what you would want to choose. And then part 2 or paragraph 2 is approval of financing. And you can check this box if the buyer obtaining financing is if this whole contract is subject to the buyer obtaining financing. And then how many days are going to be negotiated to be allowed for that buyer to get a full approval. And these are things that change in each contract. If you're in a hot market, you might even waive your buyer approval so that no matter what, they knew that that was not a stipulation or a contingency that could be utilized by the buyer. You might have a seller that only is willing to give you 10 days or 5 days, or it might be longer, it might be 30 days as far as to obtain that financing. So those are negotiating points that agents do all the time to both parties trying to get the best situation for their client. Then you have a continuation if you were using FHA or VA, and then you would come down here and sign either one buyer or both buyers, and then of course the sellers would sign off on that side. The next addenda that is attached to 8 or 9 out of 10 properties in this area is the property being subject to a mandatory HOA. And we discussed this a little bit in the offer documents. And what you have here is subdivision information under A. And I have the first box checked, which is the normal traditional box that would be checked. And this is the amount of days that you're saying the seller has to provide you with a set of subdivision documents, so that you could do your due diligence and make sure whether there was anything in there that was restricted that you might want to do. So let's just say you wanted a basketball goal in the front of your house, and you realized after getting the documents that the HOA does not allow basketball goals in the front. That might be something that caused you to reconsider whether you wanted to buy the house or not. So you give them those set amount of days in which you can get those documents, review those documents, and make sure that there's nothing in there that would cause you to want to back out of the deal. Then you come down in if there's any extra fees. So outside of the resale certificate that the seller is going to be purchasing that comes with those subdivision documents, if there's any extra fees, the normal thing to do is just to say that you'll split them 50-50. Sometimes you'll see a maximum of 100, sometimes you'll see 200. That's a negotiated fee or term there in section C. Under E, you have the authorization, and basically what that's saying is that this is a negotiated area to where the seller or the buyer would have to pay for the fee to obtain any information prior to the title company closing the transaction or ordering the documents. And then of course at the bottom you would have the buyer, seller, depending on if there's one or two of those involved. Seller's disclosure. This is the form that is utilized to show the condition of the property to the best of the seller's knowledge. Doesn't mean they absolutely know, doesn't mean that they're a handyman or a maintenance person and that they know all these things, but to their knowledge. So if they haven't had something brought up to them or they haven't noticed it themselves, then they're protected on this document. And they just go through and answer items that are in the property, whether, for instance, like the first column there is talking about cable TV wiring. And so they would say yes, no, or unknown. They would just go through all these items. And then the buyer would go through and just look at these items, how they answered them, see, what things are in the property. Maybe there's things they didn't realize. Maybe there's things they thought were there that aren't there. And so this indicates a lot of the things that are there. And then, of course, you have initial spots at the bottom of the page. And then you come into the second page is basically going over those sections and identifying any area of those sections that might need repair. So, for instance, let's just choose section 2 of this document on this page. It's going over the major elements of the house, basement, ceilings, doors, driveways, etc. And it's asking if any of those have any malfunctions or deficiencies. If they do, they're going to want information as to what they are, essentially what's wrong with the house. And you would answer that directly under that section. Section 3 is for unique conditions, is what I consider it. Things that are not that common other than maybe the foundation, settling, and maybe some termites. But you've got whether the property was used for, manufacture of methamphetamine, diseased trees, aluminum wire, asbestos. So unique issues that could be going on with the house, and you just have to identify whether yes or no if the property has any of those conditions. In the third page, you would go over, answer in more detail that if you said yes to any of those prior boxes where we were talking about here with the asbestos, foundation, and etc. If you answered yes to any of those, you would have to come in and detail those answers as to why you said yes and what is going on. Section 4 is just coming in here and saying, is there anything on the property that has not been identified in this form prior to this section that has a problem? And if so, please put down the details related to that problem. Section 5 is going in and just asking whether you've had any room additions, structural modifications, any alterations that were not in compliance or within building code. The second space there is going to be utilized for the HOA information, the management company, the contact phone number, the dues, and how often those are paid and whether they're mandatory or voluntary. So you just go down. The rest of these are things that should be read by the buyer. It can be explained in more detail, of course. Talking about rainwater harvesting, propane gas, groundwater conservation. So those are all elements that once read that could be discussed further detail. Then you come into the next page is asking whether the seller has provided a survey or not. So if they did have an existing survey that they could provide, is it attached to this disclosure or not? Then section 7 is asking, has a property inspection been completed on the property in the last 4 years? If it has, who did it, when was it done, and how big is the number of pages involved? Section 8 is talking about the tax exemptions that are currently on the property. So in Texas, most people have a homestead if it's their primary property. And then you would go through whether it's a senior citizen exemption, disabled veteran. And of course, the title company would identify this, and you would be able to find out what exemptions were in place. Section 9 is asking whether an insurance claim has ever been made on the property. So hailstorm, something, the water heater that is located in the attic suddenly burst, came through the ceiling, caused a bunch of damage. So has something gone on the property that you made a insurance claim with, and they're just wanting a yes or no. Section 10 goes deeper into this, and they're saying, if you made a claim, did you utilize all of the funds, or did you not? Did you keep the money and you didn't fix the roof? Did you, go in that route? Section 11 is asking whether you have proper smoke detectors installed per the requirements of Chapter 766 of the Health and Safety Code. And of course, then you would say unknown, yes, no, etc. You have the signatures for the sellers that, they would have already had these in place when the buyer is seeing it. And then you come down, additional notices. You've got all of the service providers, the name of them, and then of course the contact phone number. This allows the buyer to know who to contact. And then at the bottom, you have the space for the buyers to sign off. And this essentially goes over all of the documents that you would be looking at, unless you had special situations where you required other addenda. And I would be glad to go into any of these documents further, explain anything I can to anybody. If you have any questions, please feel free to call me at 469-774-3564. Again, 469-774-3564, or you can email me at jason@fellerteam.com. That's FELLERTEAM.com. Please let me know if you have any needs for buying and selling real estate in the Dallas-Fort Worth area. Thanks a lot.